much. All new here on the 5 o'clock news, we have Dr. Kevin Vance back with us from Clemson University.
Always a good day when we can talk to you, Dr. Vance. Recently, a judge blocked President Biden from enforcing a 100-day deportation ban. Could you explain what this looked like and why a judge decided to block it?
Well, great to talk to you, and I'll do my best. On January 20th, on Inauguration Day, the Department of Homeland Security issued a directive to immigration agencies saying that there had to be a 100-day moratorium on deportations. Federal law requires most deportations to occur within 90 days of a final removal order, and usually the executive branch has a duty to carry out the law, to enforce the law. But there's always a little bit of flexibility in terms of how to best allocate resources from the executive branch. Yesterday, a dramatic move happened, as you say, where a federal judge stepped in, issued a nationwide injunction, temporary injunction, where we're going to wait, where deportations have to continue until the federal courts can could consider it in more detail. But nationwide injunctions were basically unheard of from the federal courts before the late 20th century, and during the Trump administration they became quite commonplace and increasingly controversial. And so I think that clash between executive agencies and the federal courts is something that wasn't just going to be for the Trump administration. It looks like that's something that's going to continue into the future.
And Dr. Vance, what about this $15 minimum wage increase? If it happens, how's that rollout going to look, and how do you enforce that locally?
As you say, there's a bunch of proposals out there. The legislative ones involve the president and members of Congress suggesting either including a $15 minimum wage as part of a COVID relief package or maybe as a standalone bill. And either way, there would be a slow rollout where it would take several years before it actually got up to $15 an hour. But given the closely divided Senate, those legislative proposals are probably unlikely. And I think much more likely is that, again, the president will go the executive order route. We've already seen that he has issued an executive order asking the federal government to prepare a report for him, telling him how he can best promote increasing the minimum wage for federal employees. And then they've also promised that within 100 days we can expect an executive order raising the minimum wage for federal contractors. And so I think that's where the action will be, at least for the short term.
And the second impeachment trial for former President Trump just around the corner, a couple weeks away. What can we expect in those first few days? What would need to happen for a conviction in this case?
So in about a week and a half, we'll have the trial. And yesterday we had a vote in the Senate where 55 senators thought that it was constitutional to go ahead with the trial of a former federal official. 45 voted against it. So that suggests that it's unlikely they'll get 67 votes to convict Trump. But if we go back to the 19th century when there was a Senate trial of a former federal official, a former Secretary of War, some of the senators who voted that the trial itself was unconstitutional nevertheless stuck by the judgment of a majority of senators and considered the evidence in light of their judgment and decided to vote for conviction. And so we've already seen a similar thing happen in the last day here in our time period, where several Republican senators have said, even though I voted no on that resolution that suggested I thought this was unconstitutional, I'll still weigh the evidence and I'll keep an open mind during the trial stage. So it's possible, but looks increasingly unlikely that there'll be a conviction.
And of course, here back home, the fetal heartbeat bill being talked about, debated down in Columbia. If this goes further, what are we talking about as far as the cost of taxpayers, and could this still be blocked by the courts?
It's not unreasonable to expect that it will get held up in the federal courts. When other states have passed heartbeat bills in the past couple of years, they've been stopped by the federal courts. And if it were to pass and be signed by the governor here in South Carolina, undoubtedly the state will have to be willing to defend it in the federal courts in order for it to actually be carried out into law. Now, for proponents of these bills, I think that using it as a vehicle to challenge Supreme Court precedent on abortion is actually one of the features of this bill, not a downside. And so since 1973, a majority of justices on the Supreme Court have said that there's something like what they call a fundamental right to an abortion, at least up until the point of viability. And now we don't really know how the court would decide those kinds of cases because their recent decisions have been a little bit murkier on abortion questions. And we've recently had the replacement of Justice Ginsburg with Justice Barrett. And so no one really knows how they would decide it's something like a heartbeat case. So the only way to really know is to test it in the federal courts. And if South Carolina did it, they'd have to pay for the time of state officials to defend it. And then if they lost, they might be on the hook for the attorney's fees for the other side. But that's how we'll find out what the Supreme Court thinks about these kinds of bills, is if states push it all the way.
We'll have to wait and see. Dr. Kevin Vance, thank you for joining us this afternoon. We appreciate it.